Good afternoon and welcome to CCK Live. My name is Robert Chisholm. Joining me this afternoon is Courtney Ross and Bradley Hennings. And today we're here to talk about a specific case that was filed in the United States District Court of Connecticut dealing with discharge upgrades. And the case is Kennedy versus McCarthy. And recently there was a proposed settlement in that case. And it's going to have a large impact on Army veterans who served after 2001. And Courtney, can you give us sort of a background on this case?
Yes, thanks, Robert. So in April of 2017, Steve Kennedy and Alicia Carson filed a proposed nationwide class action lawsuit on behalf of approximately 50,000 veterans from the Iraq and Afghanistan era who were discharged with less than honorable discharges. In December of 2018, a judge of the U.S. District Court for the District of Connecticut granted the plaintiff's motion to certify the nationwide class of Army veterans who meet a specific criteria, and we're going to go over that what that criteria is shortly. And with the assistance of Magistrate Judge Robert Spector, the parties reached an agreement, as you mentioned, Robert, on the terms of a settlement in November of 2020. And that settlement right now is currently pending final court approval. Before it can be finalized, class members will have the opportunity to comment on the terms of the agreement in a hearing that will be held before the district court.
Brad, can you give us a little more detail on exactly what was going on in this lawsuit?
Absolutely. So specifically, the lawsuit is alleging that since the start of military operations in Iraq and Afghanistan, that the Army discharged thousands of soldiers with other than honorable OTH or general under honorable conditions GEN statuses due to misconduct attributable to post-traumatic stress disorder or PTSD, traumatic brain injury, TBI, military sexual trauma, MST, and other mental and behavioral health conditions. Additionally, the lawsuit alleges that the U.S. Army Discharge Review Board systematically denied discharge upgrade applications from those service members who experienced these conditions that had these OTH and GN discharges. So it affected both when the service members were leaving service, as well as when they tried to upgrade their discharge status. And it's important to note that in this suit that veterans who received dishonorable discharges will not be eligible.
Thank you, Brad. So which classes of veterans are impacted? The court certified a class in this civil action, and this is what we would call the settlement class, and they're defined as follows. Members and former members of the Army Reserve, and the Army National Guard who served during the Iraq and Afghanistan era in the period October 7, 2001 to the effective date of the settlement, who were discharged with less than honorable service characterization. This includes general and other than honorable discharges from the Army, Army Reserve, and Army National Guard, but not bad conduct or dishonorable discharges. So I want to say that one more time. It doesn't include bad conduct or dishonorable discharges. The people who have not received discharge upgrades to honorable and have a diagnosis of PTSD or PTSD-related conditions, or records documenting one or more symptoms of PTSD or PTSD-related conditions at the time of discharge attributable to the military service under the Hagel Memo standards of liberal and special consideration. So that's the class of people that are now eligible under this settlement. And Courtney, what is the Army's response?
So the Army's identified two groups of veterans that they are going to respond in a slightly different way. So for veterans, the Army is going to automatically reconsider certain discharge status upgrade decisions made by the Army Discharge Review Board between April 17, 2011 through the date that the settlement is finalized. So those dates are important because for any veterans that fall within that category, the Army will automatically reconsider those decisions already made. The Army says this will affect about 3,500 active duty reserve guard troops. Now, for veterans who fall between the October 7th, 2001 through April 16th, 2011 timeframe, the Army will send individual notices to the second group of veterans whose applications were previously denied for an upgrade before the Army Discharge Review Board. So they're not going to automatically review it, but they are going to send letters to veterans who fall within that category. Members of the second group of veterans can reapply and receive the benefit of the recent liberalizing laws in accordance with the settlement. And it's estimated that that second group is between 50 to 100,000 veterans that may be eligible to have the upgrades reconsidered. The Army's also making several other important changes to its general procedures in operations. This includes additional training for board members and staff who are making these decisions. It includes allowing phone hearings instead of requiring travel to Washington, D.C., enhanced notices to veterans of the legal and medical services that might assist in their applications are going to be provided, and more detailed documentation requirements that the Army Discharge Review Board must follow in any written denials that are provided.
Okay, Brad, what do you see as the next steps here?
So I just wanted to go back to one thing and clarify that when you talked about PTSD related conditions, it also included those other items that we discussed a little bit earlier, meaning TBI, MST, and other mental and behavioral conditions. So it's not just PTSD, it's these other, I just want to make that really clear. In terms of next steps, what's happened is the settlement that everyone came to agreement upon. It was preliminarily approved by a federal judge, which means that now the parties are distributing the class notices to veterans potentially affected by the settlement so that they can comment on the settlement at a final hearing. So this video, like many other efforts, are an effort to let people know this is going on. So if they're interested in commenting on the settlement at a final hearing, they can. The final hearing is going to be held on Zoom on March 24th, 2021 at 10 a.m. Eastern Time. And this is really significant for our clients and our potential clients because the type of discharge has a tremendous impact on the ability to qualify for VA benefits. If you have a bad discharge, you may not be eligible. So if you can get your discharge upgraded, you will automatically be now eligible for VA benefits potentially, because bad conduct, these lesser discharges can disqualify you. So this can make a huge difference in veterans' ability to qualify for benefits at the VA level. It can also make a big difference at the state level because the states also provide benefits to veterans, and it's often based on the nature of their discharge. And finally, it can make a significant impact on employment. Employers often want to see a higher level of discharge rather than a lower level of discharge. It can have a negative impact on the veteran's career.
So do we know who brought this suit on behalf of these two veterans?
Yes. So, no, go ahead, Courtney, please.
I wasn't sure. It was the Veterans Legal Services Law Clinic at Yale Law School that initiated the lawsuit on behalf of these individuals. And
I think it's important to point out, first of all, that this is really only the Army that has reached this settlement. We believe there's another suit pending against the Navy right now as well, and maybe that will be resolved now that the Army has resolved this issue, and potentially if there's any members of the Air Force that they would similarly get that kind of settlement. But right now it only applies to the Department of the Army. So I thought that was really important. And then Brad and Courtney, I think historically we've seen the Department of Defense in previous wars discharge people with disabilities and give them bad discharges. So this is a positive step forward that they're doing this, but they need to continue to look at the past conflicts and wars that the United States has been in to re-examine those procedures and processes as well. And anyone who is discharged has the right to have their discharge reviewed. And so there's a process that one can go through to do that. But this settlement goes a long way to hopefully correct these discharges in the Iraq and Afghanistan war. So any other final thoughts?
Go ahead, Brad.
I was just going to say, I think it's a huge step that the Army's agreed to this. We're hopeful that the Navy will get on board too. And there's a sense that if those two branches of service come to agreement, agree to the settlement, that you may have the Air Force, you may have the Marines, you may have the Coast Guard, everybody else may get in on it without the need for additional litigation, which would be, great for everyone.
Yeah, and I think just to the point you made before, Brad, about the larger impact of a discharge upgrade can have on a veteran in terms of, VA benefits, employment, and state benefits. So if that is to happen and it's expanded just more than just the Army, the larger impact for veterans could be really great.
And really, it's a matter of respect, ultimately, for these veterans, and ensuring that they're given the respect that they're due if they were discharged due to a disability.
Agreed. Well, Courtney, Brad, thank you for joining us here at CCK. And please continue to follow us on Facebook and our website at cck-law.com.